Good morning, everybody, and welcome to episode 44 of our live monthly Ask the Experts Q&A session with Sintons Employment Team. I'm David Pritchard, Head of Marketing here at Sintons. So, similar format to the other 43 sessions that we've done in this series. Up in front of you are our speakers today. We have Partner and Head of Department Keith Land and Associate Angela Carver, and obviously me doing this bit. In front of you are the three questions that the team are going to go through this morning. Obviously, Keith's back and speaking, so this could range anything between 10 minutes and 4 hours. So without any further ado, I'm going to pass you straight over to Keith.
Thanks, David. Okay. Where to start? And I'm not going to talk for 4 hours, to be perfectly honest with you. But it's nice to be back. I feel like I've not been here for a while, so I'm quite excited. Anyway, first question. If I dismiss an employee a short time before they have 2 years service, can they claim unfair dismissal? Okay. This is one of those funny little quirks of employment legislation, which we all love because basically it keeps me in a job. You would think not, okay, because the law on unfair dismissal is governed by Section 94 of the Employment Rights Act 1996. If you're a geek and you want to read it, go ahead. Andrew and I have read it many, many times. However, and that says if somebody is unfairly dismissed, if somebody is dismissed, they might have a claim of unfair dismissal. However, Section 108(1) or 108 subsection 1 of the Employment Rights Act 96 states that Section 94, which is the Section 94 is the provision that gives people a right to claim unfair dismissal, does not apply to an employee unless he or she has 2 years service at the effective date of termination. And so basically on that basis, you would think not. If you dismiss them before they've got 2 years, they can't claim unfair dismissal based on Section 108, subsection 1 of the Employment Rights Act. However, this is employment law. It wouldn't work if it was simple, would it? So there is a quirk. You'll see that the word, I use the words the effective date of termination. Most people would think that the date of termination is the date that somebody leaves. However, in employment law, it can move around. Okay, so the effective date of termination really depends on whether somebody works a period of notice or not. So if somebody works a period of notice, so they are given notice of termination of employment of say 1 week and then they leave a week later, their effective date of termination is their final day of employment. However, that changes in the event that somebody is summarily dismissed. And when I say summarily dismissed, I mean that somebody is dismissed without being given notice. In that instance, the effective date of termination is the date that they leave employment. Okay, say today, the 28th of April 2023, if I summarily dismiss an employee, they leave employment today, but as they haven't been given notice, their effective date of termination is the date they are dismissed, i.e. the 28th, plus the statutory period of notice, which for an employee that doesn't have 2 years service would be 1 week. And so their effective date of termination will be 7 days time. I can't do that in my head because I'm not that bright, but hopefully you get the picture. So in answer to the question, if I dismiss an employee before 2 years service, can they claim unfair dismissal? Well, if you dismiss them with notice and they're in the last week of, if they're into 1 year, 11 months and 3 weeks, and you give them notice, time will tick on and they'll be employed at the point in time where they have 2 years service next week, and they will be able to claim unfair dismissal. If therefore you summarily dismiss them in the last week, in the week immediately before them getting 2 years service, the law says because they've been dismissed without notice, you add on the statutory notice, and so they will then have 2 years service. The difficulty will then be is that you've summarily dismissed them without going through a process, and you'll probably come unstuck in front of the employment tribunal. Strange little quirk of employment legislation. You'll be surprised how many people fall foul of it. So my advice to you is, if you have employees that haven't got 2 years service and you need to make a call around whether you're going to continue with their employment or not, you need to make that call around 1 year, 10 or 11 months and just get on with it. At that point in time, whether you give them notice or whether you summarily dismiss them and they leave immediately on the same day, you're not going to fall foul of inadvertently tripping the 2-year rule. Hope that's clear. I'm going to pass you over to Angela, who's going to deal with the second question.
Hi, good morning. Has been a while actually since I think Keith and I have been on a Q&A together. We tend to avoid them quite regularly at the moment. So we're probably going to get stumped with them for the rest of the year. So my question is, Keith kindly passed over to me yesterday afternoon saying, oh, don't worry, Angela, this is a very quick question. You can just do one. Does a mental health condition arising from menopause amount to a disability under the Equality Act? Now, the very short answer is yes, it could well be. But I think we need to break it down really into the two different areas. So it seems sensible to start with menopause. So without teaching everyone to suck eggs, obviously menopause on average affects women over the age of about 45, but it can in reality strike at any time, particularly when you're conscious of the perimenopause, which can strike at a much younger age. But actually the symptoms exhibited can be quite similar. The symptoms also range from person to person. So saying is menopause a disability in its own right is quite subjective. Changes in hormones can have differing side effects on person to person. So you could have somebody who just experiences hot flushes and mood swings, to those who've got brain fog or a significant exacerbation of a pre-existing condition. So, for example, a reduction in estrogen can result in more depressive episodes for those living with, for example, bipolar disorder. So whether or not menopause is a disability, again, the answer is always in employment law, well, it could be. And the courts have made determinations that menopause can well fall in the definition of disability, which, again, for anyone who wants to read up, is in Section 6 of the Equality Act. And that focuses on whether or not you have a physical or mental impairment. And that literally can range from anything. It's a very wide-ranging topic, but it needs to have a substantial, and that is a subjective viewpoint, long-term. Now, long-term, everyone bats around 12 months. So could it be 12 months? Is it likely to last 12 months, or is it for the rest of the individual's life? But it needs to have an adverse, again, subjective, effect on the ability to carry out normal day-to-day activities. Now, as an employer, it's not for you to determine whether or not an employee has a disability, but you need to be conscious as to whether or not a condition could well qualify for protection under the Act. So when we're looking at whether or not somebody could have a disability, the focus really is to remain on what somebody cannot do rather than what they can do. And there's an interesting case involving Leicester Council with a lady called Ms. Rooney. And she, in fact, brought a claim suggesting that her menopause was akin to a disability. And the Employment Tribunal got it absolutely wrong because they focused again on what she could do rather than what she couldn't do. It went up to the Employment Appeals Tribunal and they overturned it and stated, yes, actually, the symptoms that are exhibited by this individual with menopause could well amount to a disability. So question one, is menopause a disability? Yes, it could well be. Then we need to look at mental health. So if an individual has the conditions and symptoms of menopause, this could well give rise to a mental health condition, which could be deemed to be a symptom of the menopause. And that would give rise to what we call a discrimination arising from disability claim. Again, if you want to check it, that's Section 15 of the Equality Act. And that means literally if you have a condition and as a consequence of that condition, you are treated unfairly, then that is potentially discrimination arising from disability. But then mental health in its own right could, going back to the Section 6 definition, be a disability in its own right there. And it really is important to note that the Employment Tribunal are not so concerned anymore with what a condition is actually defined as, but the impact of that condition. So mental health could be a disability in its own right, could be a consequence of menopause, which is a disability in its own right, or jointly the symptoms together could result in a disability. And it's quite an interesting topic because I teach at one of the local universities, and when I was teaching on disability discrimination, one of my students said, so literally, can any condition be a disability? And the answer really is yes, it could well be. So the answer to the question is yes, it could be. I'll pass back over to Keith.
See, didn't take long at all, did it? I think it's right. You're dead right. any condition, depending on the impacts on the person, could amount to a disability. And I think that's how everyone needs to approach these things. Okay, last question. And I think this is becoming more and more prevalent. We're seeing a lot more of it from opposition as employment practitioners. It's to do with trade unions, and they're all over the press at the moment anyway, aren't they? The trade union keeps posting information on social media which is inaccurate during negotiations. Is there anything that we can do about it? Look, there is a I suppose the last 12 months really has seen a great deal more union activity than we've seen in 12 years, probably. I think that is consistent with the onset of more challenging financial economic conditions, and that is the general cycle. For those of you that have been around as long as I have, it happened previously and will happen time and time again. I think the frustration that employers feel in these circumstances, or can feel, because I accept also that some organisations will have a constructive relationship with their trade unions, but my recent experience is that unions are a lot more vocal. They're a lot more challenging. They're putting a great deal more pressure on businesses, and that's not just those in the public sector that we're seeing all over the press at the moment with strikes left, right, and centre. That is private businesses that recognise trade unions. There does appear to me to be a difference between the relationship that exists with the local reps and those that exist with the regional reps. The regional reps are becoming a lot more involved, and they are more challenging individuals that are that perhaps have a different agenda. From my experience, my clients always try, or have tried, or the ones that I act with, to approach the discussions that they have with trade unions on any matter in a constructive light, but that is not always fed back. And what they're finding is they may go and have a constructive meeting, but then something is posted on social media or in a public forum that does not reflect the constructive nature of those discussions, and they find it frustrating. So what can you do about it? In some respects, less is more in this instance, I think, and let me explain what I mean by that. Any recognition agreement with a trade union is a voluntary arrangement, and so at any point in time, an employer could push the nuclear button, as I put it, and they could say, well, we're terminating that recognition agreement and you can kick the union out. I think you may turn a bad situation or a difficult situation into a worse situation should you do that, because there will be a rapid application, I imagine, for industrial action, or a ballot for industrial action, and you'll have a bigger fight on your hands. Nonetheless, as an employer that has voluntarily recognised a trade union, I think you do have more power than you think in that respect. Voluntary recognition agreements give the trade unions a lot more access than they would get under the legislative compulsory application system. So if you think that through for a minute, the trade unions' access to employees and their rights on negotiation will be much wider on a voluntary recognition scheme than they will on a compulsory recognition scheme. So if you were to terminate the voluntary recognition scheme, what's the union's option? They make an application for compulsory recognition, but that will only get them the right to negotiate on pay, working hours and holidays, which will be a much tighter, closer remit than they will want to have. And so my view would be that you are within your rights to approach the union as part of your general discussions with them. Say, do you find their approach difficult? that you can even say, well, we are considering what we do about the recognition agreement, because you need to have a more positive, constructive working relationship, and that is not coming across. And should you not get that, or should you not sit down and work through a way that those relationships are going to work better, you may consider the termination of the recognition agreement. I think you have more power in that kind of discussion than many employers think they have. However, that's not a panacea. It's not going to solve the problem. The unions, in some respects, are trying to drum up membership. They have a different agenda. They're trying to make noise that they are supporting the rights of employees, and therefore, particularly the regional reps will be pushing an agenda where they are trying to get greater publicity to show the world politically and to drum up membership what they're doing. I think what has frustrated my clients is that they try and approach these negotiations as they would approach any negotiation, which is in a professional, constructive fashion, and that is not always the way that unions work. But what I would say to any employer that faces that situation is your way forward, for me, is one of negotiation with the union, but at the same time, you need a pretty widespread communication plan, particularly if you're having difficulties with your trade union and they're putting out messages that are contrary to the ones that you are putting to them. The employees of any business are employees of the business. You are entitled to communicate with your employees at any point in time. You are entitled to communicate with them in any way you see fit. So when you are faced with this situation, I think step one is to continue negotiating. Step two is to communicate to your workforce without regard to the trade union. You don't have to talk to them about what you're going to say to your employees, but you put out communication plans that detail what you're doing in those negotiations, what the company's position is, what the offers, what offers you have made. You explain the employer's position, i.e., that you can only afford this pay offer, or you can only do A, B, and C on working conditions because of financial constraints, and that way you are giving a message to your employee that may be contrary to the one that the union is putting out there, and one that appears far more constructive. And therefore, if you have people within that negotiating group that are I suppose more pro to the employer's position, you are effectively impacting their mindsets. If things begin to escalate and there are threats of industrial action as part of those exchanges and those messages that go out on social media, well, again, I would get out there and I would explain the company's position, that any kind of industrial action has a bad impact on reputation, customers and suppliers. Prolonged industrial action and prolonged difficulties with the trade union might lead to impact on the financial and economic stability of the business, and that could have an impact on profitability and jobs. If you end up going down the road that you're going to get strike action, you're within your rights to say that employees who strike will not be paid. There could be withdrawal of holidays. Also, if you have people that are borderline, you can always talk about the fact that preparation or participation in union activities is entirely voluntary. And so if you have a group of employees that are within the bargaining unit that are wavering, you influence their mindset. And also, in a sense, what happens with these discussions when there are new union negotiations, you have a group of employees that are very pro-union, and you will have people within the bargaining unit who are all a bit apathetic about the whole thing. You need to influence the mindsets of those apathetic people, so they turn up to union meetings and they put across a point of view that is more pro-employer. You need to mobilize that group of people to put a counter proposal or a counter point of view within the discussions that the trade unions are having with the employees. And the only way that you really do that, in my mind, is by communication. So, in answer to the question at the front end, what can be done about it? Not a great deal. You can't stop the trade union putting out there what they're going to put out there. And actually, if you start getting too upset about it, the trade union will realise that they've poked a nerve. But your counter proposal is Communicate with your workforce, put the company's position out there, and hopefully that influences the mindsets of the people that you want to influence, which is your employees. I hope that helps. I think that's me done. Didn't take all morning, David, as you'll see. We're done within 20 minutes, which I think's bob on time. So I'll pass you back to David, who's going to close.
I think David's in trouble for making his comments. David won't make any more comments again. Thank you very much to both of you. Very good session. Just quickly from me, as I say at the end of each of these sessions, we're continuing to work hard to produce, release, deliver useful and relevant content, articles, podcasts, blogs, all of which can be found on our website, www.sintons.co.uk, should you wish to take a look. That includes all 44 episodes of this live Q&A session. And just from the point of view of the employment section of the website, there's a lot of content on there, so a lot of really useful articles, obviously all these sessions, and a lot of podcasts and videos of our seminars, one of which we held yesterday at Newcastle Eagles. So please do generally check it out. There's a lot of information on there. And if you're not fed up of us by that point, you can also follow the team on Twitter at Sintons HR. I've popped our speakers' lovely photos and details back on the screen there in front of you. If you'd like to discuss anything they've raised today further or any other employment issue, please do get in touch. And finally, we've hit over 2,000 people are watching this live this morning. So I didn't tell the guys that before because I was too busy being sarcastic with Keith. So anyway, over 2,000 people. These sessions just continue to grow and grow and grow. We really do appreciate it for something that we started in the depth of COVID to keep people updated with ever-changing sort of situations at the time has gone on to just be something that's a bit of a stalwart in people's diaries each month. So thank you for that. Thank you for continuing to send in your questions and for watching this afterwards. I've talked enough. I'm going to be talking here longer than Keith, so I do appreciate it. Stay safe, everyone. Have a great bank holiday weekend, and we will speak to you in May. Thank you.